Okay, good afternoon, everyone. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. Before I continue with my remarks, I'll just take a moment to introduce, first of all, our panel. On my far left, Ms. Natalia Popovic. On my immediate left, Ms. Laura Alderson. On my near right, Ms. Sophia Ruddock. And on my far right, Mr. Bill Dalton. My name is Don Taylor, and I'm the chair of the hearing this afternoon. At the far left end, my left end of this desk is our Deputy Secretary Treasurer, Barbara Bartosik. And at the far right end of this desk and in the area in front of me is our support staff. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. We acknowledge the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid, in-person, and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone, and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you're called on to speak. Those participating by video conference or video appearance will be temporarily upgraded to panelists when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card. And those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. Our hearing procedure is that I will call each item in the order listed on the agenda, with the exception of instances where the applicant has requested deferral from the hearing today, in which case we'll be dealing with those up front before we get into the regular agenda. And I think this afternoon the Deputy Secretary Treasurer will confirm when I ask her in a few minutes, but I think there are 2 of them. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, Applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5 minutes. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then, individuals either in support or opposed to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. I would first ask our panel, are there any declarations of interest for any items in this afternoon agenda?
Yes, I have a conflict with item 25. I am not working on it, but I work at Arcadis, and Arcadis Architects are working on it, so I'll declare conflict.
Okay, number 25. And staff, I'll ask the same question. Any declarations of interest? Okay, let me just write Bill's name down here. Okay. Madam Deputy Secretary Treasurer, have you received any requests for deferral on this afternoon's agenda?
Yes, Mr. Chair, items 18 and 21, I believe. Yes.
18 and 21. Okay, well, we will dispense with those initially before we return to the regular agenda. And Madam Deputy Secretary Treasurer, are there any files to close this afternoon? Okay, thank you. So we will now commence hearing the two items that have been requested for deferral by the applicant. The first one is item 18, 52 LOVILLA Boulevard. And do we have Andrew Plumbo standing right there? Hello, Andrew. Could you just tell us why you want this item to be deferred today?
Absolutely. Good afternoon, Mr. Chairman, members of the committee and Committee of Adjustment staff. My name is Andrew Plumbo of Ian Hall Planning Limited, and I am the agent for 52 LOVILLA Boulevard, and my address is 38 Betty Nagel Street in Toronto. I am here before the committee today to kindly request a deferral for this application in order to allow for sufficient time to address the comments that have been provided by various city staff departments in order to basically explore options to improve the existing non-conforming situation at the subject site. I'll give you just for an example. We've already started to explore options to improve the soft landscaping that's on site, and because that's one of the variances. And that would address city planning's request for increased soft landscaping. So that's just an example of something that we'd like to do if a deferral is granted. So as such, that's the request before the committee this afternoon. Happy to answer any further questions.
Okay, thanks. Panel, any questions? Okay, is there anyone in the hearing room that came to speak to this item that wishes to speak to it now? Yes, sir, come on up.
Good afternoon, Mr. Chair and committee members.
Can you, is that microphone on? Your name and address, please.
Good afternoon. My name is Sam Pasquale, 54 LOVILLA, and I oppose the deferral.
Okay. You oppose the deferral?
Yes.
You'd like it heard today?
Yes.
Could you tell us why?
Well, all the planning departments have responded. There was ample time to work with the planning department. There's only one item that he's referring to is the landscaping. The other three are things that cannot be mitigated. Planning department, urban forestry, and transportation all oppose this. So deferring this and coming back with a different number for landscaping is not going to change the minds of the three departments. And once again, they object to the application. So I don't see any reason why we should defer this case. It's not going to change things when we come back again. Just the landscaping, they can negotiate with you. That's why they're here. They're negotiating with you for landscaping. They want to change a few percentage, that's fine. Going to the planning department is you're preaching to the choir. We're here. Let's move forward.
So your preferred outcome would be to hear this item and make a decision to refuse it, I presume?
Correct, yes. I'm right next to it, and I have concerns. That's why I'm here.
Okay, I'm going to invite, thank you. Any questions for the gentleman? No?
Yeah, I actually do.
Yep,
You're
there
at
you
number 54?
Yes, I'm just west of the subject property on the left side of his existing driveway.
And did you need a variance for your driveway, sir?
Do I need a variance for my?
Did you need, because your driveway looks fairly wide, like it can park 2 cars, I'm just wondering if you needed a variance for that driveway.
When I went to committee a year ago, I think I was allowed 6. I can't remember. I think I got 6.1. They are allowed a maximum 2.6, and they're up to 9. They're almost 4 times what is allowed. That's not a minor variance.
So, but you did get a variance for your driveway.
I can't remember. I don't have the paper in front of me. I don't want to say yes or no. Okay, it's been a year. So I can't say.
I'm just curious, that's all. Thank you.
Okay, any other questions? All right, if you could just take a seat, we're going to have Mr. Plumbo come back and rebut your remarks.
Okay, thank you.
Again, just with respect to the deputy's comments, we still think there's opportunities to potentially even removing one of the spots that are currently being shown. That's not necessarily off the table. So there's a lot of assumptions being made as to what can be done. But that's why, again, we prefer the opportunity to talk through it with staff because, again, the transportation has requested that obviously a front parking pad permit be acquired, but there's potential improvements that could be made to the existing spaces that exist. They've existed for 18 years, but this has come up as a result of a notice of violation. And the only reason this has been pursued is because the bylaw enforcement officer actually advised my client that going through the minor variance process to legalize it is the best course of action. So this is why we're here today. But again, we only know the comments to address once the staff reports come out. So there wasn't sufficient time, and I'd just prefer to have that extra time to do whatever is possible and explore all options to improve. Again, for example, urban forestry, I think there's a clarification needed that tree that's directly beside the existing driveway and parking space has existed as it has, and it may require an arborist to take a look at it, for example. It's not just a closed door on options, and potentially additional tree plantings could be considered. So this is my reasoning for wanting to request additional time to properly address as much of the comments as we can.
Okay, thank you. Panel, any questions for Mr. Plumbo? And there's no one at home that wishes to speak to this item?
No, Mr. Chair.
Right, okay. So I think we've heard what we need to hear to render a decision on this. So let's have a motion. Can either defer it or hear it.
With that, I'd like to move a motion for deferral. I think the application should have more time to do some more homework and checking with staff.
Thank you, Mr. Dalton. Is there a seconder for Mr. Dalton?
I'll second that motion.
Thank you, Ms. Alderson. All in favor? Deferred by unanimous decision. Thank you very much. We'll see you next time.
Thank you for your time.
Okay, thank you. Okay, the next item where we have a request for deferral by the applicant is number 215 Edenbridge Drive. And the agent, Peter Milchin. Hello, Peter.
Good afternoon, Mr. Chair and committee members.
We are requesting a deferral. We did revise the application. We actually eliminated several variances, but in the process of having the Buildings Department review for a revised zoning certificate, they determined that they miscalculated building length previously, which results in a building length variance being requested, which is greater than what was on the notice. So because a new notice is required, we are requesting a deferral so that can be handled by staff.
Okay, thank you. Panel, any questions? And do we have any outside interest in this?
No, Mr. Chair.
Okay, thank you. Let's go into committee for a motion.
I'm happy to make a motion for deferral.
You're a seconder for that
I'll
motion.
second that.
Thank you, Mr. Dalton. All in favor? Deferred unanimously, and we'll see you when we see you. So we can go back into the agenda. First item is number 19, 457 Valermo Drive. Just bear with me for a second. I'll just read a quick summary. The purpose is to construct a second-story addition above the existing ancillary structure, a detached garage, and to convert the existing ancillary structure, the detached garage, into a garden suite. There are 3 variances. We have urban forestry requesting denial. We have a planning condition, and we have 2 opposition letters. So I think in light of the opposition from people and agencies, we need to hear from the agent, Faizan Akhtar.
Good afternoon, honorable members of the committee. My name is Faizan Akhtar of FA Engineering.
Yeah, thank you.
Address is 1230.
1237 Woodbine Avenue, correct?
Avenue, Toronto, Ontario, M4C4E5.
Okay, thank you.
So,
Yeah, if you
can I
could-
begin? Okay.
If you could present to us and certainly minimally address urban forestry request to deny and the 2 opposition letters, and
Sure.
whether or not you're okay with the planning condition, plus anything else you want to tell
Yes.
us.
Sure. So what we have proposed here is a second floor addition over an existing garage. And that addition would be used as a garden home for we're housing the owner's son who's having some difficulty finding housing in Toronto. That is the main reason of conversion of that garage into a garden home. And I think the opposition letter, it's 2 opposition letters, but they both are from the same tenant. There's the main home there is being used for tenanting, and that tenant is being given a eviction notice. It's with the landlord board, right? Tenant and landlord board right now. So that is, I think, his concern is that, I mean, the garden home would take away some of his storage. But the homeowner, I spoke to them this morning, and they're willing to even propose a small storage shed for him to be used for his storage. So that should be okay with him as well. Secondly, the condition, the concern from urban forestry there. We are working with an arborist, and we will apply to have, for a permit to injure the tree. So if you would like, you can put a condition there to obtain a permit from urban forestry for tree injury. And third, I reviewed the conditions from planning department. I think they just want the plans to be followed during the stage of building code examination and construction, which is fine by us as well.
Okay, we normally get a freestanding memo when forestry recommends denial. We didn't get that one in this case, I don't believe. So anyway, we'll have to talk about that and sort that out. Panel, any questions for Mr. Akhtar? And is there anybody in the hearing room that came to speak about 475 Valermo Drive? No?
No, Mr. Chair.
Sorry, can you come up and speak into the microphone?
Is it 493 or 475? Oh, sorry.
So you don't want to speak to it? Anybody online?
No, Mr. Chair.
Okay. Then I guess we can go into committee and have a discussion if we need it, or make a decision.
I just had a question. So just to clarify, so it's a 3-bedroom house that's going to be in the garden suite? It's 3 bedrooms?
Yeah, it's three small bedrooms, I guess. Eventually, it might be only 1 or 2 bedrooms. It depends on the building code as well, right? If the building department during the building code examination, if they allow 3 small bedrooms there or not, it might just turn into a 2-bedroom. It is a small footprint there, right? If you look at the footprint, it is a very small footprint. It's about 25 by 24. So it's not a big footprint.
Anything else anybody wishes to comment on or discuss? Or if not, we can consider a motion.
Sure. I'd like to move a motion for approval. I believe the application meets the 4 tests subject to the planning and forestry conditions.
So your preference would be to disregard the lack of information from urban forestry on an alternative?
Well, it's similar to the other application that we had this morning. As they proceed, forestry will be their check and balance in terms of moving forward with any permit application, and all tree details will have to be incorporated onto that, so.
Okay. So we have a motion from Mr. Dalton. Is there a seconder?
I can second that. Sorry, I can second that motion.
Thank you, Ms. Alderson. All in favor? Opposed? Okay, that motion carries by a vote of 4 to 1. Moving on to item 20, 91 DELMA Drive. Purpose is to construct a new duplex dwelling with an attached garage. We have 5 variances. And we have urban forestry requesting conditions either to deny the application or impose conditions 1 and 2 for a private and a public tree. That's really all the information we have on the file. I've noted it down as being, in my opinion, straightforward. However, if anyone would request a presentation, we can arrange for that to be done.
Just to confirm, there's 6 variances, right? Or is there 5?
I only see 5.
But we got in the additional materials last night, they're noting 6.
I didn't get additional materials on that. Oh, yeah. I didn't get the additional material. I got was minutes from the meeting where we deferred it. I don't know if I got outdated information here.
It's dated February 6, 2025, item 20, 91 DELMA 6. But the big package has 5. Okay, so they've got it.
So are we dealing with 5 variances?
Then why was there earlier one in the additional material last night?
That was what was applied for in February.
February 24th.
Yeah. Okay.
So are we agreed that we do not need Mr. Romano? We do not require a presentation from Mr. Romano? Do we agree? Mr. Romano?
Good afternoon, Mr. Chairman. Franco Romano, Action Planning, 321 Lakeshore.
Hi, and I take it you've been listening to our conversations on various topics related to this application? And that you...
Yes.
Okay. And the panel does not feel it needs a presentation. It's a pretty straightforward application. Would you be okay with just entertaining a question or two if we have any in lieu of a presentation?
Yes.
Okay, good.
Yes, certainly. And it is 5 variances.
Yes, good. Good to hear. So, panel, any questions or comments for Mr. Romano? No? And Camille, anyone in the room here to speak to this application?
No, Mr. Chair.
Anybody at home?
No, Mr. Chair.
Nobody anywhere?
Nope.
Okay. So let's go into committee and make a decision.
I'm prepared to bring a motion, Mr. Chair.
Go for it.
Thank you. On the basis of the notice dated February 24th, 2025 with 5 variances, I propose to approve with urban forestry condition. That's the only condition I'm aware of.
That's right. Yep.
Yep.
Seconder for Ms. Popovic's motion. No seconder? Okay, Ms. Rarick, thank you. All in favor? Approved unanimously. Thank you very much. Item 21 was deferred. Item 22, 429 Kipling Avenue. Purpose is to construct a 1-story industrial building at 429 Kipling Avenue. And there's 1 variance. We have urban forestry requesting refusal. Oh, and planning requesting deferral. So, Mr. Key.
Unfortunately, you have to deal with me today, Mr. Chair. My name is TJ Sakura. I'm the president of Design Plan Services. Stephen just couldn't be available here today.
Okay. So I'm just going to take a look here because I think we have another case here where urban forestry didn't do a freestanding. No,
we did not see a memo from urban forestry.
Yeah, we normally get one, but there's twice today we didn't. Anyway, so very straightforward, but there's 2 significant issues here. One of them is urban forestry requesting refusal, and the other, the planning department requesting a deferral. So if you can address it,
Mr. Chair, just to be clear, I think that it's the other way around. I believe planning submitted a report requesting a refusal of this application. There's a report dated March 14th from the planning department, which we're aware of and I'm willing to address.
Okay, they're recommending refusal, sorry, not deferral.
Yes.
Yes, okay.
And we obviously disagree with the conclusions and the
Obviously,
recommendations of the planning report.
So we'll hear you out. Go ahead.
Okay, just prior to starting the presentation, if I could have staff pull up the presentation that we submitted, but I would like to note that there's a small correction to be made to the variance identified on the public notice. The public notice identified a minimum of 29 parking spaces permitted. It should be changed to a maximum of 29 spaces permitted. Because if we were providing 51 where a minimum of 29 was required, there would be no variance. In this case, there is a maximum permitted and we're exceeding that maximum.
Does this qualify as improper notice? Typo's good for me. Okay,
We agree that it's a typographic error. Okay. So the proposal is to construct a new 1-story industrial condominium building on the subject property. There's 1 single variance related to the number of parking spaces in the flanking side yard. We did submit a planning justification letter dated March 14th. It provides a comprehensive review of the proposed variance. If we can go to slide number 2, please. This is just a chronological timeline of the process that we've been through. I would like to note this was in front of the committee and it was deferred to today from June of 2024. August 1st, 2024 to today. The purpose of the deferral was to work with planning staff. We worked extensively with them. As you can see, all the dates. A site plan application has been submitted, and unfortunately, they still maintain the position that they don't want parking in the flanking side yard on Horner Avenue. Go to the... just to acknowledge, one of the changes that was made to the application between the deferral and today was 2 accesses, one onto Horner and one onto Kipling Avenue, have been removed. So that was a significant issue of the planning department, and we think it makes a better design, a better application for this industrial building, that there will be only 2 existing accesses remaining, and 2 existing accesses will be closed, one onto Horner, one onto Kipling. Additionally, I did review a Metrolinx memo dated March 11th, 2025. While we have no issue with the advisory comments, they did recommend conditions of approval, and we feel that those are inappropriate to be dealt with at a minor variance stage. They are site plan conditions. They're warning clauses. So we will deal with that at the site plan stage.
We don't impose or create Metrolinx conditions.
Thank you, sir.
Regulatory regime, you deal with them offline.
Absolutely. So slide number 3, the subject property is located at the southeast corner of Kipling and Horner Avenue. It is designated core employment. And the proposed industrial condominium building is a permitted use. The character of the surrounding area includes a mix of industrial, manufacturing, and warehouse buildings of different scales that range between 2 to 3 stories in height. Slide number 4, please. This slide shows the photos of the subject property and the current streetscape along Horner. The site was occupied by an old industrial plant that has largely been demolished as of today. There's just some site cleanup happening yesterday, today type of thing. Slide 5, please. This slide shows a rendering of the proposed new industrial condominium building. As you can see, there's a significant amount of tree planting along Kipling and along the Horner Avenue frontages. This will enhance the existing streetscape and provide appropriate screening for the parking spaces located in front of the building on Horner Avenue. Slide 6, please. So this is the proposed site plan of the proposal. As you can see, there's a significant amount of landscaping, and the parking has been limited as it relates to the corner of Horner and Kipling, which is a prominent corner, and it has been broken up by landscaping in the frontages of the units. The building will be divided into 13 individual condominium units owned and operated by local small Canadian businesses. It's important to provide parking in close proximity to each of those 13 units. This will contribute to the appropriateness. This contributes to the appropriateness of the variance for additional parking in the flankage yard. I will just also note that the zoning bylaw does not regulate where the parking can be in terms of along the frontage. It just regulates the number. So planning staff's concern largely relates to keeping the parking away from the corner of Kipling and Horner, and that has been done. And with the landscape screening, you really won't be able to see a lot of the parking from the prominent frontage, which is Kipling, and then the flankage yard, which is Horner. Go to slide 7, please. So this is just quoting the proposed variance. There's only one. It pertains to the 51 parking spaces along the flankage side yard, where only 29 are permitted by the zoning bylaw. The purpose and intent of this bylaw provision is to limit the amount of parking along the street yard and to maintain and enhance streetscapes within employment areas. I think you can see by the previous slides that that has been done and is the intention of the applicant. Again, it's important to note that the zoning bylaw does not prohibit parking in the street yards. It just limits the number of parking spaces that can be permitted. The parking spaces are broken up and separated by additional landscape elements and planters. Slide number 8, please. So this map shows the existing parking conditions of the surrounding properties. Through a site and area visit and through this analysis, we've counted the front yard and flanking yard parking along this area and along Horner. and we've measured the length of the main walls using GIS as well. This analysis reveals that most properties along Kipling and Horner in the surrounding area exceed the permitted maximum number of parking spaces. 75 Horner is 41 over, 160 Horner is 141, that's the detention center, 141 spaces over the permitted limit, and 541 Kipling as a couple of examples. 541 Kipling is 141 spaces over, 120 spaces where 52 are permitted. Slides 9 to 12, I'm not going to spend too much time on, but the staff can scroll through them slowly. They just provide the examples of the existing context around this property, and they show that there are multiple examples of parking between the road and the main building. So if we go to slide 13, please. We've identified 3 past COA approvals that required relief from the same bylaw section. The site plan approved for 541 Kipling is on the screen there. It had a similar street parking variance and approved in 2022 by the Committee of Adjustment. Based on all this information, we feel that the variances meet the 4 tests, and I would be happy to answer any questions the committee may have.
Okay, thanks, panel. Are there any questions? Yes?
Thank you, Mr. Chair. Mr. Agent, it might be a justification letter, but I don't recall. What is the calculation as between, did you say 13 units and 51 parking spaces? In other words, what's the proportionality? How do you get to 51?
So the 51 is not the total parking provided on the site. That's just the parking on the Horner Avenue flankage. And so those will just be distributed. There's not going to be any assigned parking. It's just available for occupants of those frontages. There's also going to be parking on the Kipling Avenue frontage and on the flankage yard on the east side of the building. So there's no distribution per unit. There is a traffic impact study and parking utilization study that justified overall a reduction of parking, but still the overall parking is compliant with the bylaw. So these are just general spaces available for any tenants of the 13 units, but in proximity to where their front doors are going to be. Planning staff are asking us to move all the parking that we can off the front of the building, which would mean that essentially some of those 13 units would not have any parking in front of their building units.
Thank you.
Any other questions? Comments?
Just a comment. I like the fact that you said you were providing spaces for Canadian businesses, so thank you for that.
She used to be mega.
Well, by the nature of the size of these units, that's who's going to locate here.
Camille, is there anybody in this room or at home that wants to speak to the subject?
I have a comment.
No, Mr. Chair.
Did you want to say something?
Yeah. So I'm just looking at your cover letter. So the SPA, you had your pre-application meetings in 23 and 24, and then the formal application when and when? Because you're stating on page 1 of your cover letter, you got notice of complete application February 27th, 2025. So really the SPA application's only been before city staff for like 3 weeks.
The site plan application was made on October 24th, 2024. It took them until February 27th to deem it complete.
Have you gotten any comments out of them?
There's been a few trickling comments, but planning staff didn't want to deal with it until this process had concluded.
But then they're asking for a deferral of this process.
They're asking for refusal.
Yeah.
So if, for example, this committee decided not to approve the variance, there would be a redesign or resubmission required through the site plan process.
So are they looking for less parking?
They're looking for less parking in the flankage yard against Horner, not less parking overall.
So how could you shift it?
It would be very difficult, if not impossible, without reducing the number of units or floor area of the building, which is not commensurate with official plan goals to try and bring businesses into the city, particularly in the core employment designated areas. It's all about preservation of business opportunities and employment opportunities.
So then their issue is the number of parking along Horner.
That's correct.
So if you were to take that away, you can't put it really anywhere.
That's right, we would lose building area.
Because you've got that, the corner which you have to keep open, at Kipling and Horner, that they'd want open. And you
Yep.
can't add any more on Kipling.
We've looked at many, many, many options, and
Have they suggested reducing the number of condo units?
they have not made that suggestion, but it's implied if you can't meet the parking and you have to put it somewhere else.
Got it. Thank you.
Any other comments, questions? So we're ready to go into committee for a motion?
Mr. Chair.
Ms. Popovic?
Having considered all of the submissions and the materials, and considering the comparables, which we've seen on the presentation today, I think on balance this application does meet the 4 tests. I would move to approve with, I don't see a condition. Do I see?
Right. Thank you, Ms. Popovic. Is there a seconder for Ms. Popovic's move?
I'll second that.
Thank you, Mr. Dalton. All in favor? Opposed? Oh, you're approved? Okay, approved unanimously. Thank you very much.
Thank you very much, Mr. Chair, members of committee.
Moving on to item number 23, 493 Valermo Drive. Purpose is to construct a basement walkout and widen the existing driveway. There are 2 variances. I had this listed as, in my opinion, straightforward, not requiring a presentation, but we do have you at the microphone, so you are more than welcome to present to us.
Oh, thank you very much. I didn't create such a beautiful formal presentation, so I will put that as a proviso. I thank you to the committee members and Madam Chair as well for having me today.
You're Sarita.
I am Sarita. I am the homeowner, and I've worked tediously for the past year with community planning and the various departments, bylaw, as well as transportation and urban forestry to get it to where we need to get it to in order to be in compliance. And the goal essentially is to build a walkout basement suite, falling in line with the objective of affordable housing and providing housing, as well as to have a parking pad in the front, which currently existing right now on the existing driveway is 4 feet, and the proposed width, which is why we're asking for the variance, is 6 feet. In addition, we have worked tediously with Anthony Socia of Community Planning to increase the soft landscaping to make it in compliance with the city's requirements, which is why it was deferred previously from the last hearing. So I'm hoping that it's all in order.
Okay. Any questions, comments for Sarita? None?
Yes, so I just wanted to ask about the planning memo from October 2024.
Yes.
Previously just had 16%, right? Now you've upped that to 48%.
Correct.
And planning is quite pleased with that now?
Yes, they are, yeah. I worked tediously with them, had several meetings, so we always want to be in compliance, and that was always our goal.
Good, thank you.
Yes, thank you.
And Sarita, are you aware of and okay with the Transportation Department's 3 conditions of approval?
Yes, so we worked with them to extend the curb cut. So that way there would be an entranceway for a car to get in there. So we've asked their approval, and they said as long as community planning approves the project, that they would go ahead and stamp the drawing as well, extending the curb cut.
Okay.
And we would pay, of course, whatever was required of us to the city.
Okay, so just, it's quite a long, detailed set of conditions, so just make sure you understand it and.
Yes, of course, we'll be in full compliance.
Perfect. Okay, we're ready for a motion.
Sorry, Mr. Chair, there's somebody online who would like to speak.
Oh. Yes, hello, could you introduce yourself, give us your name and address, and say what you need to say?
Yes, good afternoon. Good afternoon, Mr. Chairman. This is Franco Romano of Action Planning Consultants at
Oh, yes.
321 Lakeshore.
Okay.
And if staff can bring up my presentation slides, please.
Sorry, the applicant has spoken, so you can't speak as well.
Not here as the applicant, Bartosik. I'm here for the
I'm
neighbor
so
at
sorry, we have you
493.
listed as the
Valero.
agent again.
Yes, I understand. This is the second time that's occurred, and I
Yeah,
appreciate
I'm so sorry, Franco.
No worries, Bart. Appreciate it.
If I may, to the committee, was this pre-approved ahead of time? I wasn't made aware of.
Anyone is permitted to speak.
Oh,
Yeah,
I see.
it's a
Okay.
public hearing.
Okay.
But Sarita, you'll be given an opportunity to rebut whatever Mr. Romano says.
Of
So I
course.
don't know if you want to take notes or. just
Of course, I will.
be
Thank
prepared
you.
To address what he says.
Sure, please go ahead.
Thank you kindly, and appreciate staff bringing this up. So page 1 shows the subject site.
I'll just try to-
Is it okay? May I proceed?
Sorry, Franco, who are you representing? I just don't.
I was just about to do that, but then I heard
Okay.
something, and I thought I was speaking out of turn. So, okay. So, thank you, Mr. Chairman, members of the panel. I'm here acting on behalf of 495 Valermo Drive, which is a neighboring property to the west. The landowners are Lisa and Justin Norface and Susan Prince. I acted on their behalf, helped them get a second-story top 2022 in March of 2022, and the driveway remained as it exists at that time. So my client opposes the proposal because its approval will condone the applicant's removal of the existing driveway and the existing rear yard parking. The existing driveway includes a mutual right-of-way. It has a driveway width of 3.08 to over 9 meters when it enters into the backyard, extending into the rear yard. That has been removed by the applicant by placing a fence over top of the right-of-way, mutual right-of-way. And on slide 1, you will see in magenta and in orange a rectangular box that goes from Valermo Drive at the top to the backyard. That is a mutual drive. On the site plan, I've shown in an oblong red circle that there is a proposed fence, but that fence exists. That fence has been erected by the applicant over top of the right-of-way, preventing my client from using a mutual right-of-way, preventing the applicant from using that driveway and accessing the backyard for parking. The Transportation Department memorandum anticipates, I don't think they've reviewed the site plan appropriately because they say that access to the site is currently provided from Valermo via an asphalt driveway along the side yard of the property to a detached garage located in the rear of the property. The fence prevents that from occurring, and the proposed widened driveway would facilitate a front yard parking pad and remove that rear yard parking access, not only for my client, but for the subject property. My client also opposes the proposal because it will prevent my client from using the existing mutual right-of-way. The site plan shows that fence that's already been erected. My client wishes that fence to be removed. The proposal will also invite conflicts with unacceptable adverse impacts regarding access and visibility. The proposed driveway and parking arrangement will conflict with my client's use of their driveway and will inhibit visibility of the public sidewalk that's right adjacent to where their proposed parking space is to be located. Staff has brought us to slide number 2, I believe it is. In my opinion, the proposal seeks a driveway arrangement and parking solution that is, number 1, inconsistent with the prevailing location and design of driveways and parking areas. That conflicts with the official plan, section 4.1.5. Number 2 is inconsistent with the built form and site organization policies of the official plan under section 3.1.3, which seeks to minimize the width of driveways and curb cuts across the public sidewalk and limit new and removing existing surface parking and vehicular access between the front face of a building and the public street and sidewalk. You will see in slide 2 that staff have brought up, this is the condition that the subject site was in before the applicant decided to remove the entirety of the front yard landscaping and widen the driveway. And I understand in their revision, they have reduced the amount of or I guess they are proposing to increase the amount of soft landscaping. If we go to the next slide, slide number 3, we'll see a 2000 survey. The survey was done in the year 2000, which shows a previous condition as well. And you'll see that that mutual drive brings us into the backyard, and there was a board fence within the backyard that allowed for access at 493, but that's been since removed. If we go to slide number 4, we'll see front yard parking. This is the applicant's photographs. Slide number 5 shows the rear yard area in front of the garage with a fence that's been erected by the applicant to their garage. So one cannot access that garage from the front via the driveway because of the fence that's been erected along the mutual drive. However, the backyard has mostly hard surface, so they can clearly park back there by removing the fence that's on the mutual drive. So the variance for driveway width that is at 6.99 meters is inappropriate, does not satisfy all 4 tests for a minor variance. And I might say that the 6.99 meter driveway width that's being proposed conflicts with the applicant's cover letter of January 21, 2025, and the site plan, which shows a driveway with a 5.03 meters, but it's essentially not a driveway, it's a parking space in the front yard. Thank you, Mr. Chairman. Happy to answer any questions.
Okay, panel, any questions for Mr. Romano before we move on? No? Okay, Ms. Samaree, you have up to 5 minutes if you need it.
Yep, thank you very much. So to be clear, why part of the reason why this project was created to begin with is that, first of all, my proposed project does not impede whatsoever on the neighbor's portion of the shared drive. Where the property line is, I actually put that wooden fence, and for reference, that is my garage, which is now used for storage, not the neighbor's garage. So where that fence exists, it's actually 1 inch over to the property line, and they have 12 feet on their side, which they sit comfortably 4 cars. In fact, they actually park cars on the street because sometimes they have an excess. You can also see, thanks to the photo that my friend has shared, that there is a 12-foot container that often remains there. So they have more than their amount of space. What had happened was we had excessive amount of damage during the construction of their home. They have had open permits for about 3 years. We have brought a statement of claim against the neighbors for the excessive amount of damage that they have caused, and that's currently being heard in the courts. To give examples, they didn't put proper locates down, hit a gas line, which then caused the tree in the front, which you showed, which were older photos of my front yard, a maple tree, which Urban Forestry gave us permission to take down because the tree was dead. In addition, they caused excessive potholes on my side of the driveway as part of the damage, which they had agreed to repair but never did. They went with a bobcat into my garage door. That garage door that you see there was a replacement garage door that they had to fix. So part and parcel of the reason why I no longer wish to share a driveway with my neighbors. And again, they're not impeded whatsoever. They fit, and I repeat, 4 cars comfortably on their side of the driveway, and they can come in and out as they please. The curb cut where it currently exists favors them. They can get in and out. Right now, I struggle with the only existing 4 feet that I have severed for myself, and I explained this in detail over the past year to community planning, as well as shared my statement of claim against the neighbors. So I have impeded my access, which is why I am asking for that parking pad. And again, we're only getting 6 feet. They have 12 feet. So the overall width of the shared driveway was 16 feet in width. They can still access from the curb cut to the back of their home. I don't have anywhere to park because, again, we have cut off access for safety reasons, because, again, there's ongoing damage that keeps occurring and trespassing on my property by their contractors. So we were left with no choice, and having discussed this with bylaw, there is, in fact, an exemption under bylaw 569/2013, subsection 10.5.8, 10 subsection 5, and whereby an individual is creating a secondary suite. There is an exemption if there is an existing driveway in which that can be expanded. So in order to meet that requirement and satisfy the city's requirements, we met with community planning extensively, had several meetings in person here at Etobicoke Civic Center, and they have advised it's in compliance. The fence is in compliance. I've met with both managers of bylaw enforcement, and again, what we are permitted to do under city standards is connected to that wooden fence. We are allowed a 4-foot fence as long as it is see-through, wrought iron or chain link, to extend 1.2 meters back from the sidewalk, and that is permitted. It doesn't affect transportation. We had a temporary construction fence, which is in place currently, and we haven't started any construction, of course, without the consent of committee, but it is 1.2 meters back. The neighbors have called on several occasions by law, in which we're addressing that matter as well. But again,
Ms. Sarma, you have about 20 seconds.
Oh, sure. So again, we are in compliance. We have met with all the city officials. They've approved it, along with when that tree pre-existed, urban forestry approved removing the tree to accommodate the parking pad.
Okay, thank you very much. Panel, any questions or comments for Ms. Samaru? Okay then, I think we're ready to go into committee for discussion if needed, or a motion.
Motion? No discussion? Sure. With all that, and thank you for all that background, that's quite the tale. I do believe the application meets the 4 tests, so I'll move a motion for approval, subject to the extensive transportation comments.
I'll second that.
Thank you, Mr. Dalton and Ms. Ruddock. All in favor? Opposed? Okay, that motion carries by a vote of 4 to 1. Thank you very much.
Thank you kindly to the committee. I truly appreciate it. Thank you.
Thank you. Okay. Item 24, 100 Glenaden Avenue East. Purpose is to construct a new detached dwelling with an attached garage. There are 7 variances. We have clearances from TRCA, Ravine and Natural Features. We have 3 Community Planning Department conditions and Urban Forestry conditions 1 and 2. And the agent is, looks like David Eagleman. Yes, it is. So, Mr. Eagleman, tell us all about your project.
Yes, good afternoon, Mr. Chair, committee members, and staff. David Eagleman, Design Plan Services, Inc., 87 Skyway Avenue, Suite 200. And I'm here on behalf of the owner. I don't think the committee would require a full presentation, but this application, just to provide some brief background, this application was unfortunately deferred twice. First from the January 23rd committee hearing, and then from the February 6th committee hearing of this year. The first deferral was a result of missed variances on the zoning notice. Those were then identified on the zoning notice, and because it was just for missed variances, we were rescheduled by committee staff right away for February 6th. But once those missed variances were identified, planning staff then had some issues with those variances, those new variances. So we deferred on February 6th to consult further with planning staff and try and come to a resolution with them. And specifically, those were in relation to the length and depth variances. We have worked with planning staff. We have revised the proposal, and planning staff are now satisfied. We've reduced the length and depth to some degree. The variances didn't change much for length and depth as a result of our revisions, because the length and depth is measured in the basement, whereas the revisions we made were to lower the length and depth at the first and second floor above grade, whereas the basement, planning staff were satisfied with the basement staying the same. So the variances ultimately didn't really change, but planning staff was satisfied with those revisions. And we're agreeable to the recommended conditions from planning staff as well as from urban forestry. TRCA and RNFP have no concerns or conditions, and I'm not aware of any comments or concerns from any neighbors. We actually did obtain a few letters of support from some of the surrounding neighbors, and it is my professional opinion that this application meets the 4 tests and the variances are minor. So I'm happy to answer any questions.
Thanks, Mr. Eagleman. Panel, any comments or questions for Mr. Eagleman? Camille, anyone in the room or at home to speak to this one?
There is somebody online.
Okay, let's
A neighbor.
hear from whoever that is.
Hello? Oh, great. I think I've been unmuted. Can you hear me?
Yeah. Can you give us your name and address?
Sure. My name's Brian Burkett, and on behalf of myself and my wife, Maura McCaskill, we're at 115 Riverwood Parkway. So we're the adjacent property to the 100 Glenaden application. So there were just 2 concerns that my wife and I would like to raise. The first was in respect of the number of variances, and I gather there were 7. I don't think we've been able to identify the adjustments to the materials that we were looking at in advance of the February 6th Committee of Adjustments hearing date. That was adjourned to today, March 20. And I heard something from the speaker about the length and the depth. You know, the last word we had was that, you know, in terms of our property line, it was moving about 2.5 feet closer than allowed, hence the need for a variance. And in terms of the driveway itself, it was 3 feet wider than allowed. It could be that our information is outdated, but our concern, it's just a concern, is that when you take the cumulative effect of all of these variances, does it really remain minor? That was the concern, number 1. Number 2, I'm not sure if you're familiar with Riverwood Parkway. We live on the ravine side. So our house, like pretty much every house on Riverwood, is a bungalow split level that looks out on the Humber Ravine, which is awesome. And by the way, Laura, we're all Canadians. And the character of the neighborhood is such that it's very low. it's very horizontal. I'm not sure there is another two-story house on the ravine side. There are a couple where there's been a box that's been put on the existing roof line. So it's just, our hope, my wife Maura and I, is that the committee is taking these two factors into consideration as you reach your decision, which we will be comfortable with. I will say, in addition to the question, but I'm not sure we've seen the changes to the layout from earlier. You know, urban forestry did have a problem with a couple of trees. One was a fairly significant maple tree out near the road, and the other was a tree inset closer to the houses. And in terms of that second one, it was the view of urban forestry that our approval should be given in respect to this application. We've not been contacted about that to discuss it with our new neighbor. So those are our concerns. Happy to answer any questions or listen further to the first speaker about the changes to the plan.
Okay, thank you. Panel, any questions for the neighbor? Okay, David, would you like to rebut, please?
Yes, through you, Mr. Chair. So just in regards to the first comment, just about the number of variances, obviously I'm sure the committee understands that, you know, the number of variances is not necessarily a factor in determining whether the proposal meets the 4 tests. You know, each variance has to be considered individually and cumulatively. And, you know, in my opinion, the variances are minor, just to provide, because I didn't provide a detailed presentation, just to provide some context in relation to the variances. The length and depth of the building will match the existing condition of the house. The existing house is a bungalow, whereas we are proposing a 2-story dwelling, but the front wall and the rear wall will be located with the exception of the basement, will be located in the exact same location as the existing dwelling. So really that is an existing condition that's just being maintained with this proposal. The rear yard setback is also measured to the basement, whereas above grade for the first and second floor, the rear yard setback is actually compliant and exceeds the minimum rear yard setback requirement. And in reference to you know, the coverage, again, the coverage is a very minor increase. The FSI as well is a minor increase that's consistent with the redevelopment trends within the neighborhood. I did provide a detailed cover letter addressing all of this. And just in respect to the comment from the neighbor about, you know, from what I gathered, it seems that the neighbor feels that he wasn't made aware of the changes and wasn't made aware of the application, but we were, as I mentioned initially, we were deferred twice. So it's been, you know, this is the third time this application is coming in front of the committee. There have been changes between then, but for this hearing, for this application today, we've submitted revised plans and a revised zoning notice. We've submitted a detailed cover letter addressing the revisions. Public notice would have been sent out by city staff to the neighbor. We've posted a sign on the property as required. So and all the information is available on the city's website, so on the AIC. So the neighbor, while I appreciate may not have the knowledge of how to access all of these materials, it is all, you know, provided on the public notice. And if the neighbor went to the application information center, he would have found all the materials and the justification letter, which addresses the revisions and where we are at with the application. So in respect to the height, we're not seeking a height variance. We are compliant with the height. And in regards to the comment about the trees, again, forestry has provided a memorandum for today's hearing date and has indicated standard condition number 1 and 2, which we're agreeable to. So I'm not aware of any concerns from urban forestry or any other city department at this point. So those are my comments, Mr. Chair.
And you may have said it, and I missed it, you're okay with the planning conditions, 3 of them?
Yes, we are agreeable to those.
Panel, any more questions, comments for Mr. Eagleman? Okay, I think we can go into committee then for a motion.
Okay, with that, I'd like to move a motion for approval. I do believe the application meets the 4 tests subject to the forestry and planning conditions.
Thank you, Mr. Dalton. Is there a seconder for Mr. Dalton's motion?
I will second that.
Ms. Popovic, thank you. All in favor? That's approved unanimously. Thank you, Mr. Eagleman.
Thank you, Mr. Chair and Committee.
Moving on to item 25. Oh, yes, Mr. Dalton's excusing himself. Thank you. 4,000 Eglinton Avenue West. Purpose is to modify the development standards from site-specific bylaw 767-2020 LPAT and to create additional dwelling units to accommodate the proposed buildings. There are 8 variances. And on file, we have a Metrolinx advisory. We have opposition from 151 La Rose Avenue. We have support from Demetrius Church, which is, I know, immediately to the east of this property. Transportation is okay, and the planning department and the local councillor have requested deferral.
Check.
And you are presumably Charlie Smith.
Yes, Charlie Smith, 3 Church Street, Suite 200, representing the applicant. Through you, Mr. Chair, thank you all for your time. Just the deferral, that I believe was a previous deferral request just on the AIC. We were cleared with planning staff to proceed with today's hearing, so we're not requesting a referral unless that has come in at the 11th hour.
Sorry, I just want to do a quick check here because
It was just missing from your package, the previous deferral memo.
Yeah.
So it wasn't in that upfront deferral memo they always send?
No. It was just to give you context why it was deferred previously.
But we do have a deferral request letter from the councillor, correct?
I think that was old as well.
Oh.
That was from the previous package.
I delete all remarks regarding deferral.
Okay. All right. I can do a brief, a condensed presentation for the committee
Sure.
should they see fit.
Please.
So.
And sorry for that. That's my fault.
Thank you. So if I believe it's Thomas is controlling, can we go to slide 2? Just I'll use that as a starting point. So for the committee's benefit, this process began back in November 2024. The application, as you mentioned, sought to add additional stories to an existing approval, which was an OLT settlement in 2022. The subject site's generally at the northwest corner, so the northeast corner of Royal York Road and Eglinton Avenue, and is among an existing apartment neighborhood. Thomas, we go to slide 5, please. So the proposed variances propose to increase tower heights of the 2 westernmost buildings, Tower A and B, from 25 stories to 27 stories. Tower C, which was previously approved at 25 to 29, and the tower on the far east would remain at 25 stories. So there are a series of additional variances which were triggered by the additional height. However, the impacts with respect to the variances primarily focused around shadowing and net new impact on both St. Demetrius Church and the Catholic District School Board property to the east. So that was the original request from the councillor for deferral to ensure there was additional conversations and consultation with those adjacent parties. Could we go to slide 13, please? So during the 2022 settlement, as I mentioned, there were parties involved, including the Catholic District School Board and St. Demetrius Church, which are located generally to the northeast and to the east of the property. So as the applicant, we contacted these adjacent neighbors to notify them of the forthcoming application early on in the process. And as I mentioned, the request for deferral from the councillor on the January 23rd date, we accepted and engaged in additional conversations with the school board, the church, as well as a meeting with Councillor Holiday. We've come to agreements with both parties and have a positive recommendation report from both transportation staff and planning staff. I will note that the applicant is entering into a Section 45-9 agreement, which will provide $218,000 to be used at the discretion of city staff. And this is also in addition to local improvements secured through the settlement, including a new 2,700 square meter or 0.2 hectare park, which is on the site. And generally, with respect to the variances, it's my opinion they are minor. They meet the intent of the official plan and using land efficiently within apartment neighborhoods, which will be proximate to future transit improvements along Eglinton Avenue. The variances maintain the intent and purpose of the site-specific bylaw, which seeks to accommodate a mix of uses on the site. Notably, one of the variances is actually increasing non-residential GFA at grade to provide additional potential for retail and service uses for the community, in addition to providing new housing in this location. Just respect to shadows, these slides are within the presentation that show the net new impact from those height increases in the purple outline, generally extending to the northeast in this image. And the core focus was reducing impacts on the areas to the east, including outdoor play areas associated with the school board and some passive recreation space as well. And as I mentioned, we've come to mutual agreements with both those parties and have satisfied their concerns. So it's my recommendation that the application does meet the 4 tests, and I'd be happy to answer any questions. Thank you.
Thank you, Mr. Smith. Panel, any questions or comments for Mr. Smith? Camille, are there any parties that wish to speak to this, either in the room or at home?
No, Mr. Chair.
Thank you. So I think we're ready then to go into committee and make a motion.
Okay, Mr. Chair, I'll make the motion, having reviewed the documents and heard the submissions. I believe, on balance, this matter now having been deferred from January 23rd meets the 4 tests, and I'm going to move for approval. With the capital improvements, the density cash contribution and are there other conditions that I'm missing?
I don't believe so. Anybody else?
Okay.
Okay, so we have a motion. Is there a second? Ms. Ruddick, thank you. All in favor? That's passed unanimously.
Thank you all for your time.
Thank you, Mr. Smith. Let's give Mr. Dalton a minute to attend. She wants a break? Would you like a break, Natalia? Would you like a break, or you're good?
You want a 5-minute break? It's 20.
You want a break?
25. We're 26. How about a 5-minute break? Okay, sure. 25. Oh, yeah.
It's got to be a 7-minute break.
It's going to be a 7-minute break?
Yeah, 2:30.
That's 2:32.
What, do you want 12?
No, Oh, 7-minute break. It's 2:23. Sorry, that clock is not correct.
2:35. That's the number.
At 2:30.
235.
2:35?
We're just having an afternoon break. We'll be back at 2:35. Thank you.
237.
Okay, we're ready?
Everybody start their camera.
Yeah. I think so.
Don, your camera's off.
Oh, yeah, my camera is on. Thank you. There I am. Okay, we're on item number 26. 41 Edgecroft Road. Purpose is to construct a new detached garage in the rear yard. There are 5 variances. We have urban forestry condition 2 requested, as well as a community planning condition. There are no other agency comments or comments from neighbors on the file. I don't think, Camille, do we have anybody in the room? I think I know why the people in the room are here.
We have somebody online.
We
Mr.
do.
Chair. Yeah.
Okay, well, let's hear firstly then from Mitchell Kutu is the new agent. So Joe Dome is the agent. Okay. Joe? Dome? Mr. Dome?
Yes, Joe Dome, 133 Torresdale Avenue, agent for the owner.
Okay, we're going to be hearing from a Mitchell Kutu in a minute, so maybe in anticipation you can just outline briefly your application.
Sure. For a quick background, the application was deferred at the previous hearing on February 6th due to a public notice error for variance number 2, which referred to an east setback instead of the correct west setback to the exterior side lot line. The neighbor at 39 Edgecroft understandably pointed that out in their letter before the previous hearing. Now that direction has been corrected on the notice. The proposal itself is relatively straightforward with a number of existing conditions on a corner lot. The owner would like to rebuild an existing rear detached garage, which is in poor condition. The existing garage is 45.6 square meters and the proposed garage is 49.05 square meters. So a 3.45 square meter increase is proposed to accommodate some additional storage space. Excuse me. As it relates to variance number 1, the existing lot coverage is 37.6% and the proposed lot coverage is 38.26%. The proposed garage itself meets the bylaw for accessory building coverage at 9.92%. Variance number 2 refers to the proposed west side yard setback of 4.27 meters. This is mitigated by the fact that the proposed garage does not extend any closer to the street while also meeting the bylaw for the interior side yard and rear yard setbacks. We have worked with planning staff prior to the original hearing to meet their requirements for improvements to the soft landscaping, variance number 4, by adding a larger rear planter, as well as replacing the existing stone walkways on either side of the driveway with permeable materials. Variance number 5 for the driveway width, 9.45 meters, includes those walkways and has been an existing condition for at least 30 years. So staff requested that those walkways be improved with permeable materials. The owner agreed. That is shown on the revised drawings. And in light of the aforementioned changes, after review, planning staff had no concerns and recommended a tie to site plan in their report. And variance number 3 refers to the proposed height of 5.37 meters, which is necessary for accommodating a car lift for the owner to work on his car. The height is mitigated by the gable roof design, and 2 properties to the north along the street at 55 Uno Drive, there's also an existing detached garage with a taller gable roof design. I'll also note there's no curb north of 116 and 109 Uno Drive, which is the rear neighbor, and transportation staff have no comments. And urban forestry, as mentioned, urban forestry have noted condition number 2. And overall, we feel the application is reasonable and minor in nature. I'd be happy to answer any questions you may have.
Thank you. Panel, any questions for Mr. Dome? Okay, let's invite Mitchell Kutu to speak to us.
Yes, good afternoon, Mr. Chair, panel members, and Committee of Adjustment staff. My name is Mitchell Kutu. And if I can ask staff to pull up the presentation material, if possible. possible? Yep, perfect, fantastic. Thank you for the opportunity to speak today. Again, my name is Mitchell Kudo. My wife and I are the property owners of 39 EDGECROFT Road, which is the immediate neighboring home to the east of subject property. We are long-term residents and have been living at this address with our children for the past 20 years. We are happy that the applicant is planning on building a new garage. However, we strongly believe variances number 3 and 5 do not meet the 4 test. And I'll begin with variance number 3. So the proposed height is not minor in size. It's an additional 34% greater than the maximum permitted height, and the impact is substantial in nature in respect to mass adjacent and sun and shadow impact. So if you could please reference slide number 1, the one that you have up. Just a little history here. In 2008, the applicant built a new 2-story home that extends well past our home by approximately 18 feet. To the left, you can see their brick home. Although we knew this would have a huge impact on us in respect to personal enjoyment of the rear deck, my wife and I did not object and instead respected and supported the applicant's wish to build their dream home. If you could please reference slide number 2. For the last 17 years, we were able to mitigate this impact of the additional 18 feet that extends past our home, okay, by retreating to the far end of our backyard, which is adjacent to the applicant's garage pictured there. There, my family and I, friends and extended family, spent a lot of time together enjoying the open air and natural sunlight. This photo shows our view of the existing garage at the rear of our backyard. To put things into perspective, the existing garage wall that you're looking at there to the soffit is approximately 6.5 to 7 feet high, for a combined height of 17 feet 7 inches. When you factor in the grade height difference at the property line shown in the photo, the total height is almost 19 feet from our grade. Please note in this photo, the gap or open air space between the applicant's house and the proposed new garage would be marginal at roughly around 22 feet, hence the mass adjacent. In conclusion to variance 3, as seen in photo number 1, in 2018, we decided to invest and build our forever home. We built a new 2-story home on the existing footprint. We did not extend back in order to respect longtime neighbors to the east. We adhered to all bylaws, maximum limits, and did not have to go to the Committee of Adjustment for a new build. There is no doubt the proposed new structure height would greatly impact us further and extremely limit, possibly eliminating our enjoyment of the backyard due to mass adjacent and lack of natural sunlight. On behalf of my family and I, we are kindly asking the committee members here today to take our concerns into consideration, and please not approve variance number 3 and maintain strict adherence to the maximum permitted bylaw height of 13 feet or 4 meters. Next, I'd like to speak to variance number 5. Okay, and you can reference photos 3, 4, and 5, and we can start with slide number 3. It is clear the applicant's intent. Actually, before I go further, the proposed driveway width is egregious and not minor in size. It's an additional 58% greater than the maximum permitted width and goes against precedents in the area. Site plan shows a stone walkway adjacent to the north side of driveway that is being used as a parking pad. Impact is substantial and poses a danger to pedestrians, and I'll explain. So on slides 3, it is clear the applicant's intent is to legally park 3 vehicles across the width of the driveway. Again, this is a precedence-setting issue. On slide number 5, if you can reference that, photos show that when the parking pad was installed, if you can go to slide number 5 right there. Photo shows that when the parking pad was installed, they also dug up the grass on the boulevard and patched it over with asphalt, likely without permits. You can still see the witness line between the patch and original driveway just a few feet south of the basketball net post. If you can please advance to slide number 6. Perfect. Photo on the left shows that the applicant has installed a new fence butting right up against the sidewalk, disregarding any fence setback, and in the process created a blind spot between pedestrians and drivers pulling out of this driveway. Photo on the right, once again, shows blind spot with vehicle parked on the stone walkway. You will also notice the neighbor to the south on the right there was kind enough to install the new fence and respected the proper fence setback. Anyone familiar with this area will know that there are plenty of residents walking the neighborhood at all times of the day, many dog walkers, seniors, young families with toddlers, often at times running or riding bikes ahead of a parent or grandparent. Mr. Chair and panel members, I believe we have an opportunity here to prevent serious injury or a loss of life and to ensure that pedestrians arrive home safely to their loved ones. That's it for me. I'd like to thank you, and I'm open to any questions for clarification here.
Thank you, Mr. Kuto. Panel, any questions or comments?
Yeah, I just want to go back to the setback for the fence that was erected. When was that put in? What year? Do you know?
If you go on Google, if you go on Google Maps,
I've got 2020. It was definitely there in 2020.
Yeah, and I believe it was there in 2011. If you go on Google Maps, or if you look at slide number 5, that's a Google Maps photo. That was
there was a hedge there in 2015.
Yeah,
it was replaced by a fence
yeah.
somewhere in that time period. Okay. Thank you.
Yes.
Yeah, there's no there's no setback on the fence. It's strange to see it. Okay.
Anything else for Mr. Kuto? Okay, Mr. Dome, you have an opportunity for rebuttal now.
Yes, we do appreciate the neighbor's comments. And regarding the height, I would point out that the difference in height over the as of right is 4 meters to 5.37, and we do feel that with the gable roof design and the actual impact to light by that additional increase would not be that significant. Also including the fact that the lot line, the setback to the lot line, complies with the bylaw. Regarding the driveway width, as far as I'm aware, that was an existing condition, and as I'm not sure about a fence as it applies to a variance to the zoning bylaw. It wasn't identified by the zoning examiner. All I can comment on is what's in front of us today, and the improvements that were proposed to planning staff in regards to their comments. And I'd also note transportation did not have concerns with the driveway width variance as well. Also to refer to the safety comment, I'm not sure. I mean, while we do sympathize with the safety concerns, I'm not sure how the difference between the increased driveway width to the safety concerns would be how the safety concerns would be increased over a regular driveway.
Panel, any questions for Mr. Dome? No? We're good?
No, thank you.
So let's go into committee and make a decision.
So with that, I'd like to move a motion for approval. I do believe the application meets the 4 tests, subject to the planning and forestry conditions.
Thank you, Mr. Dalton. Is there a seconder for Mr. Dalton's motion? No? So that motion fails. Can we have another motion?
Mr. Chair, I believe the other motion would be to refuse this application.
Well, defer or refuse.
Pardon me?
Defer or refuse, those are the options.
We've heard the application, now we have to refuse it.
I would suggest that the motion to refuse on the basis of not satisfying all of the 4 tests, and I note the issue of the minor nature or lack thereof, perhaps in the variances, would suggest refusal.
Okay, thank you. So we have a motion to refuse from Ms. Popovic. Is there a seconder for that motion? Ms. Reddick, thank you. All in favor? All opposed? Motion to refuse carries 3-2. Bill and me refused. The other 3 approved. Okay, moving on to item number 27. One Carswell Place. Purpose is to construct a 1-story rear addition to the existing dwelling, a new parking pad in the front yard, and to convert the existing attached garage into habitable space. And this item was deferred on February 6th because the applicant wished to make some revisions to the proposal. The registered speaker is the owner, Kinga Surma.
Yes, I'm here.
Yes, hello. Okay, if you'd like to tell us, you said you wanted to make some revisions a month or so ago, maybe tell us about them. And just so that you know, or probably you do know, Urban Forestry has requested their condition 2, and there's a planning condition. Are you aware of and okay with them?
Yes, sir, we are.
Okay, good. All right, so maybe you can tell us what you've been up to on this property since February the 6th in terms of revisions.
Gladly to. Thank you, Mr. Chair. Thank you, committee members, staff, and I just want to extend my gratitude to planning staff as well as community planning staff that worked with myself and my architect. We've made several revisions, as you can see, bringing the variances down to 2 from 5. The purpose of this project is really to house my aging parents. They would like to be close to me, as well as accommodate my mother's medical condition, which would ultimately free up their rental unit for another family that would like to live in Toronto. I have spoken to all of the neighbors surrounding the property, and they are supportive and have expressed no concerns to me about the project. And I've also included a photograph from the street view so that you can see that the addition will not really change the street view of the home. And so we're just very grateful to be here, and again want to express my gratitude to City of Toronto planning staff and community planning that helped us throughout this process.
Okay, thank you, Ms. Surma. Panel, any questions or comments for Ms. Surma? Camille, anybody online or at home that wishes to speak to this?
No, Mr. Chair.
Okay, then. So we have the 2 variances, urban forestry condition 2 and a planning condition. Can we have a motion?
Mr. Chair, I'll make the motion to approve. I believe that the changes to the notice since the deferral from February 6th meet the 4 tests, and I include in this motion the planning condition and the forestry condition.
Yep.
Okay, thank you, Ms. Popovic. Do we have a seconder?
I'll second that.
Thank you, Mr. Dalton. All in favor? That is approved unanimously. Thank you, Ms. Surma. Okay, the last item of the day is number 28, 405 the Kingsway and 1 EDENBRIDGE Drive. We have 2 consent applications and 3 variance applications. This item was deferred on January 23rd of this year for consultation with Urban Forestry ravine and natural features protection and community planning. And subsequent to that date, we now have a planning condition of approval. The Transportation Review Department is okay. We have recommendation to refuse by ravine and natural features, or alternatively an imposition of their condition 2 regarding a 70-centimeter white oak. And we have opposition from the Humber Valley Village Ratepayers Association. And we have a letter of opposition from 3 EDENBRIDGE. And we have Agent Anthony Gornick. And we have, I guess in the hearing room, we have Mary Flynn Guglietti and Ann Anderson. Am I right? Ah, okay. And so, ma'am, you are? Ann Anderson. Okay, so I guess firstly we'll hear a presentation from Mr. Gornick.
Hello, can you hear me?
Yeah. Hi.
Hi. Anthony Gornick here, agent for the application.
Sorry,
We wish to share, sorry, go ahead.
Are you speaking or is Mary speaking? So that's the question.
Can we share the presentation or can only one or the other?
It should be one or the other.
All right, then I'll step down and ask Mary to speak, if that's okay.
Thanks.
Good afternoon, Chair and members of the committee. Can you hear me okay?
Yeah.
Great, great. Thank you very much for your attention today. Mr. Gornick and I were going to take our 5 minutes, even though there are 5 applications in front of you, and split the time. So we weren't going to use up more than our 5 minutes, but if you would prefer only one of us speaking, I would be happy to speak. I do want to note
Either
that-
of you can speak for 5, or you can split into 2.5 each, or 2 and 3, whatever you want.
Okay, why don't we do that? Because I think Mr. Gornick has actually been working on this file for approximately 2 years and has had, wonderful experiences working with staff and negotiating through the process. So I think I would like him to speak for the first 2.5 minutes, and then I will take over when he's finished, if that's to the
Okay.
committee's liking.
I'm just going to ask staff
Thank
to
you very
start
much.
the clock.
Yeah.
Okay. Go ahead.
Hi, so the application's related to taking 2 municipal properties, 405 the Kingsway and 1 Edenbridge Drive, and creating three separate parcels and 3 properties. In doing so, we've had extensive conversations with the planning department, and subject to all the dialogue with them, they have now supported the application in doing this. The first part at 405 the Kingsway, we plan to retain the existing stone home, and the property size will be 24.14 meters with a lot area of 1,215 square meters. The second parcel, part 2, will have a lot frontage of 19.21 meters and a lot area of 728 square meters. And the third parcel we wish to create would have a lot frontage of 19.8 meters and a lot area of 826 square meters. As this relates to the area and the properties in the direct vicinity, the parcels that we propose and the lot sizes are fairly consistent with the existing homes on Edenbridge, and exceed in size to the homes abutting us on Hartfield and across the street on the Kingsway. So we've had some back and forth as the property was deemed a natural heritage, and we've had a extensive study that took us 3 seasons. And with the planning department's peer review of our submission, they deemed that they agree with our natural heritage study, and there's really nothing a part of this property that is sort of has the characteristics that you would normally sort of have as a natural heritage study property. Ravines and natural features have expressed some concerns as it relates to one tree We currently do have a permit in place from 2020, and in our new submission, we plan on.
Mr. Gornick, your 2.5 minutes is almost up. If you wanted to do an even split with Ms. Flynn Guglietti.
I'll step down and let Mary take over. Thank you.
Okay. Well, you still have 12 seconds.
Mary, chime in, please. Thank you.
Thank you. I think what Tony was trying to finish off in those 12 seconds is that he already has a permit in place with respect to the tree that's been identified by Mr. MacDita. So quite frankly, that's already been granted. And so really should not be a concern to the committee. What I'd like to talk about is in reviewing the letters of objection, the focus seems to be very much on that it's the same application that went to the Committee of Adjustment and was approved by the committee back in 2017. It went to an appeal, and that appeal at the City of Toronto's Appeal Board basically allowed 2 instead of 3 lots. But the difference at that time is, I think it was the concerns about the natural heritage. And that has since been very subsequently highly reviewed. There was a peer review undertaken by city staff, outside of city staff, and they have agreed with the conclusions that there are no natural heritage features on the property, and it is simply a manicured lawn. And that was one of the main issues that was discussed over the 6 days of the hearing. The other really important thing to remember as well is that we are now living in a time where the policies have substantially changed since 2017. As you know, the Planning Act has been amended several times since then, and the focus in the amendments to the Planning Act is to create more housing. We are in the middle of a housing crisis, and you'll note that in Section 34 of the Planning Act, it now talks about having as of right the ability to have a second unit, and where there are 2 units, you can automatically have a 3rd unit, and there are no rights of appeal. What else has changed is the provincial policy statements. We now have the provincial planning statement of 2024. And under section 2.2b, it talks about the necessity of municipalities throughout the province of Ontario facilitating all potential housing options. And it encourages the increasing of the housing, and it also is very much so focused on increasing the housing supply. The other thing is that we have the City of Toronto's official plan. We have now laneway housing. You can have a house behind a house. All of these are an attempt by the province and the city to ensure that we have more housing. And how do we achieve
Ma'am, you have
more
about
housing?
20 seconds to wrap.
Thank you very much. I wanted to go to the city's OP, and I'd like to point out in the city's OP, particularly Chapter 4, Policy 5, talks about the criteria that you have to look at. And if you look at the criteria and the housing in the general neighborhood and the immediate neighborhood, you will find that the lot frontage, the lot area, all of the variances that are being sought are very much prevalent in the neighborhood. And therefore, I submit to you that the 4 tests under the Planning Act have been met in that it generally complies with the official plan, generally complies with the zoning, is an appropriate development of the lot for this time and age and with our housing crisis. And they are, in fact, minor, particularly compared to the numerous other examples that have been provided by Mr. Gornick
I've got to
in the
stop.
materials that
I have
he's
to stop you
provided
there.
to the
I have to
committee.
stop you there. Thank you. I have to stop you.
Thank you.
Yeah, you're welcome. Panel, any questions for either Mr. Gornick or Ms. Flynn Guglietti? Okay, so we can move on to our speakers, those that wish to speak today. And I think the only one I have on my list is Ms. Anderson from the Residents Association. So I'll call on you then to speak. You can certainly speak. I'm just trying to give deferential treatment to those that are on this typed list.
Good afternoon, Anna.
Good afternoon.
Can you hear me? Yes. Ann Anderson, 17 Elstree Road. I'm speaking on behalf of the Humber Valley Village Residents Association. This almost feels a little bit like a bad movie. We do believe this is essentially the same application that TLAB denied in 2018, where the panel member was Ian Lord. At the time, the City of Toronto, Vicky Russell, the neighbor, and HVVRA were parties at that TLAB hearing. It was an exhausting 6 days with many, many, many hours of preparation time prior to that. Following the 6 days of evidence, TLAB ruled that the policies of the natural environment provisions of the official plan preclude any development that would impact the rear portion of the property, not just the one tree, since it's part of the natural heritage system. His ruling stated one appropriate new dwelling can be accommodated on the site, and that ruling would protect the old trees bordering Ms. Russell's property. The ruling allowed Mr. Gornick 8 months to determine the precise location of the boundary to create 2 compliant lots. He did nothing. Anticipating this possibility, however, TLAB ruled in the event the owner is unable to achieve compliance within the time requirement, TLAB may be spoken to, but failing which the appeal is allowed and provisional consent and variances provided are refused. Yes, much has changed since that TLAB decision, but we essentially have the same application to split into one lot into 3, retain the existing house, which, by the way, was also a condition of the TLAB ruling, and to build 2 additional houses. The policies protecting natural heritage systems from development have not changed. Those black oaks, not just one oak, there's many of them, are still standing and they remain protected. There's been no evidence presented to suggest otherwise. We feel it's really an abuse of power for the TLAB decision to suddenly come around a few years later and be overruled by this hearing. We'll see. HVVRA has no objection to the applicant severing his property into 2 compliant lots and building a home on the new lot. We think it would probably be a spectacular home. Our objection is to the property being divided into 3 non-compliant lots, 31 and 38% smaller than permitted, 2 new houses, both larger than permitted, and most importantly, causing the injury and destruction of rare oak trees and a natural heritage system, contrary to the 2017 ruling. So we ask the committee to deny the application.
Can I just ask you a question?
Yes, sir.
In your view, maybe you don't know how everyone on the Residents Association thinks, but I'll just ask you personally. What is preferable? 2 4,000 square foot houses on 2 lots, or 1, and I did the math, an 8,600 square foot house would be permitted as of right on this 39-meter lot if it were left as a single. Assuming nobody has a problem with severing 405 the Kingsway. The issue is the rest. Is it 1 lot or 2? That seems to be at essence here. So what's better, 2 4,000s or 1 8,000? In terms of acceptability, compatibility, massing?
There are a lot of very large houses, 8,000 square feet on Edenbridge.
On the golf course side, yes, but not this side.
Yeah, you're probably right
This
there.
side's very different. I mean,
Yes.
and
No,
Hartfield's
I would
very
think-
different, and the Kingsway is very different.
Well, our
Anyway.
big, I hear your point.
Yeah.
Yes.
I'm not trying to drive anything anywhere. I just want to know. You know, you think about.
Well, the advantage to a very large house is the trees, the old oak trees, would all be retained. And that, I think, would be beneficial not only to the neighborhood, but also to the neighbor. And yes, we have heard from residents about the destruction of the trees. I've never asked them that question, an 8,000 versus 4,000. I guess one could argue both ways, couldn't you? But the trees themselves are...
I've been struggling with this point myself. I'm not speaking for the rest of the panel, but yeah, it's, you know, you got to be careful what you ask for sometimes.
For sure. And there'd also be 2 driveways. That's a busy corner. Believe me, it's a busy corner. I've made my statement. I just, it's frustrating when I think of the hundreds of hours we've put into this over the last number of years. It's exhausting. Mm-hmm. So that's our statement.
Okay, that's fine. Appreciate it.
Thank you for your time.
Any other questions for Ms. Anderson? Okay, and I guess we have Ms. Russell?
Yes.
I think you spoke, I was here in January, and I think you spoke, no? I know what you did, Ann.
No, we were all parties at the TLAB hearing, and Vicky and I, we were both here in January, but the application was deferred.
Yes.
I came up to simply, I was here.
For that deferral.
Yeah, I was here recently for the nursery on Scarlet Road, and I spoke very briefly. In fact, I said, I can't add anything to what's already been said.
You like that one?
Yeah, I was there.
Okay, all good.
Thank you.
Yeah, never forget that one. Yeah. So Ms. Russell, remind us where you live again and then speak to us.
Is that on there? Okay. Yes, committee members. I live next door at 3 EDENBRIDGE, and basically what it looks like is that this application is essentially the same one as that was brought into before TLAB in 2017, and that was where there were the 3 parties: the City of Toronto, me, the next door neighbor, and the Humber Valley Village Residents Association, and 70 plus letters of opposition from the residents. And at that time, the applicant was trying to divide the property into 3 lots. And as was mentioned, TLAB said that you couldn't do that. They could be divided into 2. But let's just, and I suggest that if the applicant had trouble with that, the appropriate form was to appeal the TLAB decision and not to go through this all again, which I suggest is an abuse of the process. There was a proper forum for appeal. Let's see what he's trying to do this time. There are, for parts 2 and 3, the lot frontage is 15% too narrow, the lot area 31% too small, the maximum permitted gross area is 9% too small, the side yard setback is 15% too close to my house, and exacerbated by the enormous second floor platform that would be more than 2.5 times larger than permitted and looking directly into my bedroom window. On parts 4 and 5, the lot frontage is 16% too narrow, lot area 38% too small, gross floor area 3% too small, side yard setback 15% too close. And in part 5, if approved, it would create a dramatically undersized lot and lead to the destruction of the existing old oak tree on my property. The applicant wants part 5 added to the property of part 4, which is right next door to my house. And parts 4 and 5 would have a combined lot frontage, which would be too small. In part 1, the original house, he wants to put a side yard setback that would be 15% too close to the new house. And if you drive by the properties, you can see it's a very narrow, pie-shaped wedge of property where he is wanting to divide this. Collectively, the number of variances cannot be considered minor. It's submitted that the variances are not minor. The applicant is requesting approval to radically change the property with additional of 2 new oversized houses on 2 undersized lots with undersized side yard setbacks too close to my property and with a second floor platform over 250% larger than permitted. At the TLAB decision, the TLAB has already considered some of the things about planning. And I know there have been changes since, but what TLAB said was page 25, intensification does not trump good planning, and good planning includes consideration of the environment. Intensification for residual purposes itself is shackled by a number of directives, included identify prioritization areas, policy priorities such as support for the provision needed and assisted housing, and support for infrastructure, including transportation hubs and transportation corridors. None of these are present here. And TLAB concluded, I find on balance, on severance of the subject property into 3 lots offends the official plan and does not meet the criteria of the Planning Act. And it said, in the manner the variances in terms of nonconformity with the environment policies, contravention of the bones being the intent and purpose of the zoning bylaws and the evidence, which I accept that the nature and degree of multiple adverse impacts both on the environment and the neighbor, me, is neither desirable nor minor. Now, the property has already had the removal of several 100-year-old rare oak trees that were mysteriously removed shortly before the applicant bought the property in a private sale. We do not want further removal of the trees. And TLAB did find that there was a cluster of rare black oak trees. My property contains 2 black oak and 1 white oak, and the 1 white oak is right by the property line. And TLAB said that he accepted the concern of Ms. Russell for the white oak tree, and the tree preservation zone should be of 8.43 meters to be provided, as my white oak is right there. The black oak are right by the property line at the back. Now, I had said this before when I was at TLAB, I don't object to the applicant having 1 more property on 405 the Kingsway, so that there would be a total of 2 lots, the original house and 1 other one. But I do object to what he's trying to do now. And also what I would ask if the house is built, that it have few, if any, variances, not to put a second floor platform on the house next to mine. It should only be 4 meters if that's to happen, and it should be on the other side of the property, which is what TLAB said.
Ms. Russell, you're just about out of time.
Yeah, and that my trees should be protected with the tree preservation zone. Thanks very much.
Just stay there for a second. Panel, any questions or comments from Ms. Russell? Okay. Madam Deputy Secretary Treasurer, do we allow a split in the rebuttal or ask them to choose? Okay. So Mr. Gornick and Ms. Flynn Guglietti, if you can sort this out between you, we will be delighted to hear from one of you for up to 5 minutes to offer a rebuttal.
Thank you very much. I will take the rebuttal, if that's okay with Mr. Gornick. What I'd like to point out is I believe some misunderstanding. I won't call them necessarily inaccuracies with respect to statements that were made by the 2 objectors. But I think the really critical point is what has changed since the hearing. And what has changed since the hearing? It's been 8 years, new policies, but also there was a very in-depth 3-season natural heritage impact study. And that natural heritage impact study concluded that there was no natural heritage features that would be protected under the city's official plan on the entire lot. And that matter was peer reviewed. And the City of Toronto hired the peer reviewer, and the peer reviewer said that there was an absence of natural features with the property that are not present on the site. There is no breeding habitat or significant wildlife habitat is present to be protected. And so I think that was really something that had not been borne out at the TLAB hearing. And as I have pointed out to you prior to, there is still the City of Toronto's tree protection bylaw. We still have to go through the process of having those issued or not issued. The client does have to make those applications, and they are more than adequate to do that. And therefore, I don't really think that that's the concern that everybody has pointed out. Now, with respect to Ms. Russell's property, I would like to point out that her setbacks on her property are 0.84 and 1.16, wherein the bylaw requires 1.8 meters, and in the Humber Valley bylaw, it's 1.5 meters. And her frontage is only 21.20, whereas the bylaw requires 22.50. So when she talks about the variances being requested, some of those variances are very similar or less than the variances she herself enjoys on her property. I would point out as well that with respect to the trees that are being discussed, the oak trees, that not all of these trees are going to be removed. And therefore, it is important to look at the forestry report, which really only talks about that one tree, and it's the pine tree. And that has been the review of the City of Toronto. So I would submit to you that the comments made with respect to the 2017 TLAB decision, we're in a different time, we're in a different place, a much more detailed, a much more accurate natural heritage impact study has been done and reviewed by the city, and the city acknowledges through that process that this is not a natural heritage impact site, and therefore the policies under the natural heritage impact do not relate to this property at all, and that this property is the same as all the other properties in the neighborhood. And I would submit to you, as noted before, that the 4 tests have been met, and that having worked with staff for an extended period of time to come up with an application that is satisfactory, and that the committee approve the variances that are being sought today. Be happy to answer any questions that you might have.
Okay, thank you, ma'am. Panel, any comments or questions for Ms. Flynn Guglietti? No? Okay, so then are we ready? We'll go into committee and perhaps have some discussion and then conclude with a motion. Anybody have anything?
I have a comment to add to, I believe it was the agent who was presenting initially, and she said that, you know, we have a housing crisis in the City of Toronto. We have an affordable housing crisis in the City of Toronto. We don't have a housing crisis for the wealthy. And I'm assuming that these houses are not going to be affordable housing. So I just wanted to clarify that.
I think it's noteworthy as well. It's just a very small point, but I think it's important that Ms. Flynn Guglietti mentioned is that the existing house at number 3 Edenbridge is in fact has a 1.22 meter side yard setback as opposed to the 1.8 that's required. So we do have that substandard situation in existence there. And the frontage of number 3 Edenbridge is also less than required by the bylaw, not by much, but I think it's 21.93 as opposed to 22 something. So yeah, just a couple of points to think about. Because my comment is, and I made it to Ms. Anderson, it's been keeping me awake for the last couple of nights, is this distinction between, you know, trying to address the compatibility of the built form on this property. And I haven't landed on this, but there are 2 options here. You have 2 houses on 2 lots that are basically the size of the other houses on the street. Or you have one 8,600 square foot house on a 40-meter lot that, with the exception, I know this area very well. I live in Humber Valley Village, just a little bit south. The golf course side is different. They're bigger. They're more expensive. They back onto what is arguably the best golf course in Canada. Anyway, but on this side of the street, we don't have 8,600 square foot houses. This one would look, you know, when you talk about massing, this would look massive if the developer were forced to build a single house on a single lot. And I'm certain that's one of the options he would be considering if he was not successful today or in an appeal, whatever. And that large product would be marketable on
that side of the street.
No, I mean that street is fully developed. It's mature. There's no.
The smaller, I'm talking about the smaller lot sizes. Would they set a precedent on that side of the street?
Nothing else is nearly big enough to split in lots like this. This is unique.
It's a large lot, I agree.
From Kingsway right over to Royal York Road, this is the only one in town.
And I have no problem seeing it split in two. I don't think anyone does.
Oh, no.
And you're going to throw it out?
So with that, I'm going to make a motion. I don't know how this is going to go, but let's say. Based on everything that we've heard today and the evidence provided, I think the application meet the four tests, subject to the planning, forestry, and heritage comments.
Okay, we have a motion.
You
Do we have a
mean
seconder?
Ravine? No, I don't have heritage.
Ravine. Thank you.
Do we have a seconder? We do not, therefore that motion fails. So we need another motion.
This was reviewed extensively by TLAB not too long ago. And they made a decision. Now, I understand about the, heritage review. I understand about that. But there's and actually, our chair mentioned it, there are so very few streets in the city that still have this lot size that are, that you can point to and say, oh, go and take a look at the Kingsway. It's beautiful. And, I hate to see, I would just love to see it divided into two lots, but I think three is a bit of an overreach, and so I'm going to move for refusal.
Okay, we have a motion to refuse, seconded by Ms. Ruddock. All in favor? Opposed? So the motion to refuse carries by a vote of 3-2. Thank you very much, and
I think that's.
I'll call for a motion to adjourn from. Oh.
So, if you members, this is related to item 19 for 457 Valermo Drive. And based on the forestry memo, the way the items are listed, you imposed a forestry condition. But that forestry reference was for 91 Delma, which is actually item 20, not 19.
Who made that
There
motion?
was no recommendation from forestry for 457 Valermo Drive. Now, we can't reopen an application, but we don't have an appropriate condition to impose. So I'm suggesting, with your benediction, that we put something, the applicant shall obtain clearance from urban forestry prior to the issuance of a building permit if required. Because it's just a general, there was no recommendation for that file, but because you imposed a forestry condition, we can't take it out, we can't reopen it.
Do we need a motion? Yeah.
That was an issue. It was a numbering issue in them. Yeah.
So as long as, I just wanted to state that publicly and make sure that the members.
So that will be in the minutes.
Yeah.
Do we need a motion on that, or would
No.
5 nods suffice?
5 nods.
Nod.
And now it's time for my favorite motion, to adjourn.
I'm calling on a motion to adjourn, and we don't need that seconded. That is carried. We are adjourned at 3:31 p.m. on the first day.
And thank you, ladies. I hope that you're reasonably happy with the decision here today. It doesn't mean they're not going to come back, but they're not going to come back.